for permission to appeal on the matter of Amazon.com and others and Stephan, Amazon.com and others Hammond.
Yes, good morning.
Good morning, my lord. This hearing is to determine applications by Amazon for permission to appeal from decisions of the Competition Appeal Tribunal in 2 class actions heard together at the certification stage. I appear for Amazon in the Hammond appeal, and my friend Ms. Lukacheva appears for Amazon separately in the Stephan appeal. Each of the claims alleges that certain business practices of Amazon relating to its online UK store were a breach of the competition rules. In my case, Hammond, the proposed class representative, or PCR, wishes to bring an opt-out action for damages on behalf of roughly 52 million buyers from the store. And in the Stephan case, the PCR proposes to bring a claim on behalf of third-party sellers who offer goods on the Amazon store. Now, the tribunal, chaired by Sir Peter Roth, gave a single ruling in July last year in which he made the decision to certify both of the claims. Amazon is now raising a discrete point of appeal in each case. I'll deal first with Hammond, concisely. Ms. Lukacheva will then, with your permission, address the point in Stephan.
Right. I was going to say, first of all, that I think it was listed for an hour this morning. That may, given that a slightly slower boat has been added to the convoy by my presence, give us a little more time, or you have a little more time. We ought to aim to finish, I think, by around about midday. Our provisional view was that actually we were going to ask you to take it in reverse order, namely to take Stephan first. But have you agreed the order of events or any sort of time between you?
We did. We discussed this beforehand.
Well, in which case, we won't interfere with your agreed order of events.
I'm obliged, my lord. For Hammond, you should have a core bundle and a very slim supplementary bundle with 4 tabs. And there's a joint authorities bundle covering the 2 cases. In a nutshell, the legal issue in Hammond concerns the proper approach to be taken by the tribunal to assessing litigation funding arrangements at the certification stage in class actions. And our case is that the tribunal made a legal error by treating the matter of funding for this case as an issue to be assessed at the very end of the proceedings.
First question I've got I think we both want to ask you is, what's it got to do with you?
I'm sorry, my lord, with
Amazon.
With Amazon. Oh, I see. It's an issue that affects the conduct of these proceedings in which we are the defendant. It is an issue that the claimants, for obvious reasons, do not wish to raise themselves. We are the only party who will raise this point, which I say is a legitimate and important point for consideration by the Court of Appeal.
But at some point, I think I would like to understand not only why Amazon is so interested in getting involved in the funding arrangements for the claimants. I mean, I think it was described as an opportunistic attack or application below. And why particularly does it prejudice Amazon if the issue of any issues on funding are left to the end of the litigation where the court or the CAT will have a better understanding of exactly how it's gone rather than at the start? So, it's some fairly fundamental questions.
Yes.
which certainly I have.
Yes. Can I deal with two of those immediately and then come back to the others? The point of better understanding at the end is one of the issues that we say is wrong on the facts of this case. And we say that actually a better understanding, when you appreciate this case and the issues that are raised, is obtained at the certification stage, and I'll develop that. Secondly, so far as Amazon's interest is concerned, there are 2 points. The first is, if we are right that the funding arrangements here are excessive, even outrageous, then by the time you get to the end of the proceedings, if that was the contractually agreed amount, then Amazon is at greater risk because there is a funding arrangement which is very high, which it is going to have to be arguing about as well. Furthermore, although your lordship said that Amazon's interest is opportunistic, it is quite true.
I didn't say that. That was...
No, well, although it recorded the point that it had been said that Amazon's interest is opportunistic, Amazon does have an interest, nonetheless, in seeing that the proceedings go off on a sure footing, because otherwise, as the proceedings progress, for reasons that I will develop, there will be arguments, there could be tensions, there could be matters that affect the progress of the proceedings, in which, of course, we are the defendant. One of those, which I will develop, relates to perverse incentives. The perverse incentives point is a central feature of this proposed appeal. It affects what will be done, what approaches will be made by Amazon, and the way the case will be run. And we are at the sharp end of receiving these submissions. So to that effect, to that extent, it affects us directly as well. So we say we do have an interest in raising these points. They are objectively legitimate, as I will hope to persuade the court, and they are matters that will not otherwise be raised before the court for determination. Now, our case, as I say, is that the tribunal made a legal error by treating funding as a matter to be assessed at the very end of the proceedings. The tribunal stated in its judgment that it was following an approach which, to use its words, was now authoritatively set out by the Court of Appeal, and it referred to a recent judgment in a case called Gutman and Apple, decided last April. And we will submit first that the tribunal was in error, because properly understood, Gutman and Apple does not stand for that proposition. Further, we submit that if the tribunal had properly directed itself to the applicable legal principles that are outlined in Gutman and Apple, it would have appreciated the need to deal with points that were raised at the certification hearing in the Hammond case by Amazon, which it either did not address at all, we were the party putting these points forward, or did not give any reasons for dismissing. Had the tribunal addressed those points, our points, it would not simply have waived the case through the certification gate. Stripped to its essentials, there are 3 specific points which are cumulative and need to be considered in the round as well as individually. And with your permission, I will state the key headlines now and then unpack the supporting reasons in a few moments' time. The first point is that the tribunal's decision to follow the approach it thought was set out in Gutman and to leave hanging the question of the reasonableness of the funder's remuneration until the end of potentially years-long proceedings was wrong. As the Court of Appeal, in fact, pointed out in Gutman, which we'll look at in a moment, the approach of the tribunal must recognise front and centre that this regime depends on litigation funding, that litigation funding depends on a high degree of certainty of returns in the event that the claim is successful. and that is a point which the Court of Appeal said is necessary for the tribunal to bear in mind in its decision-making. In a case such as this, where the contractually agreed return is demonstrated by Amazon to stand at a level which was described by the tribunal president in a recent past case as indefensible and as requiring to be called out at the certification stage, it was particularly wrong to flag up expressly, as the tribunal here did, that there is a serious concern, and then say it will all be looked into at the end, rather than grasping the nettle at the gatekeeping point. So that's the first of the three.
Can I just ask you on that? What's the proposition of law you say the tribunal deduced from Gutman?
From Gutman, it says that it was following the approach authoritatively set out, which is, generally speaking, the default approach is to deal with funding at the end.
Well, that's not what it says, is it, in paragraph 64? What it says is, it is now clear from Gutman that the tribunal can scrutinise the fees at the end.
It refers to the following the approach. Shall I open that now? Otherwise, I'll come.
Well, it's quite an important point. This is it's the whole foundation of your case, isn't it? It's an error of law.
It is
Yeah.
that it's an error of law. This is not the only point we're going to be relying on the error of law. But if I turn to paragraph 64 directly, as your lordship's referred to it. My bundle appears to be slightly odd. Right, sorry, we're looking at paragraph 64, of course, of the tribunal's ruling.
Yes.
Yeah.
Yes.
Yes.
Sorry, yes.
Yes. It's the fourth line there. This is in line with the approach now authoritatively set out by the Court of Appeal in its judgment in Gutman.
Yeah. But you've got to look at what that is. That's the previous sentence. At the end of the day, the amount of the funder's fee or return which will be paid is subject to the scrutiny and approval of the tribunal. So on its face, it's suggesting that is what the approach now set out by the Court of Appeal. Not that there's some rule that it should be then. It's always a matter of decision by the tribunal, isn't it, in its case management powers.
Well, my lord, we say no, that the proper way to understand that is that they believe that that was the default approach which was taken in Gutman and which was laid down as the approach that should be followed in a case unless exceptional circumstances are shown. It was the default approach. And you'll see that that's supported later in the judgment, I'll come to it, where they refer to, if you turn the page to 66 in the judgment, reliance on an Australian federal authority, which was not canvassed in argument at the hearing. We note the full federal court in Australia, with much more experience of class actions across a wide field of claims, said in Money Max, court approval of a reasonable funding commission rate is to be left to a later stage, when more probative and more complete information will be available to the court. And then in its permission ruling, which is at tab 5, paragraph 17, you'll see, this is on page 102, the last few lines, as stated at 64 of the ruling, that approach has been endorsed by the Court of Appeal. Now, I understand, my lord, that the tribunal was not saying that it's something that must be addressed only at the end of proceedings. Its position was that, by and large, this is something that should be addressed at the end of the proceedings because of the presence of what it considered would be better information, unless there was a reason to address it up front at the gatekeeping point. And that is the point that I wish to delve into, because I say that that approach is based on an error of law and an error of logic when you understand the system. That's the point I would wish to develop. So that is the first point. If I may, I shall develop that in a few moments. I turn to the second consideration, and this is a second point flagged by the Court of Appeal in Gutman, but entirely unaddressed by the tribunal in our case, which is the problem of perverse incentives that I referred to a few moments ago. And what that really means is conflicts of interest between the funder and the class about how or when to settle the case. Where at the certification stage, as here, there is shown to be a serious issue of perverse incentives, the case should not just be allowed to roll forward and allow, therefore, those perverse incentives to work their effects. This is such a case. That was demonstrated. And putting the matter off until the end of the whole proceedings cannot solve that problem inherently. And the tribunal did not address that dimension at all, although it was a part of the submissions that were made to it. And that is a point that I also developed. The third point is this.
So your point of law is failure to consider a relevant factor.
Yes.
I.e. an exercise of discretion, but based upon a failure to take into account relevant matters.
Yes, that here there was a relevant matter that that wasn't even addressed by the tribunal that would have taken it in the other direction. The third point is this, that there is a further key matter that was referred to by the court in Gutman. The Chancellor there pointed out that one of the two essential safeguards against excessive funder returns, which is built into the system, is that the proposed class representative will have negotiated an appropriate and competitive funding agreement. In a case like this, where it's admitted that the funding agreement was made in conditions where there were no competitive offers at the time, but where competitive offers can be expected to have been forthcoming from the market afterwards and now, again, that should be taken into account. It was not, and the case should not just be allowed to roll forward regardless. To pick up on what my lords were saying a moment ago, the potential justification for putting the matter off is that the tribunal will be better informed at the end of the day. It doesn't apply in this type of situation, leaving aside what I've said about perverse incentives being allowed to operate, because a relevant question will be, what were these competitive terms available back at the time, the certification hearing? And the tribunal will be better informed on that question at the relevant time. The tribunal either didn't deal with these points at all in its ruling, or it failed to apply them to the facts of the case, as the evidence showed and in line with its findings at the hearing. So stepping back, we say that this ground is well arguable as a point of law, for reasons that I'll flesh out a little further in a moment, and should be considered by this court. But additionally, the issue raised is a matter of major current significance in the developing field of collective actions, and that is why there is some other compelling reason for the appeal to be heard. And to appreciate the wider importance, may I ask you please just to open our skeleton for a moment and look at tab 2 in the core bundle. In it, go to page 19. And if you look at paragraph 9, and just read that to yourselves, you'll see that there were submissions made to the Department for Business and Trade, which published the call for evidence in August last year, by two major associations. You had the International Legal Finance Association itself, and their submission, 5 lines down, the CAT should bring forward the approval of funding terms to CPO stage so that there's an assumption that the funding terms as approved will stand unless there is very good reason to depart from them. Pausing there, that is essentially the opposite of the approach that the tribunal thinks is the correct approach to take. Providing greater certainty to the returns to funders through respecting funding terms and waterfalls through early approval of terms by the CAT would help mitigate the risks that increase the cost of funding or put funders off funding cases altogether. Then you'll see that there is a supporting convergent submission by the class representative network, which is worried about the fairness to funders, and concerns are raised that the CAT's willingness to revisit terms at the very end will make it difficult for funders to be able to assess the potential return on investment when deciding to invest in the case.
Well, when you're saying it'll be beneficial for the Court of Appeal to have the opportunity to give guidance in this sort of area, I mean, the first question is whether the Court of Appeal has already given guidance in this area in Gutman. So, you're going to have to go to Gutman pretty fast, I think.
I'm going to go to Gutman. What I'm going to say is that the approach that's been taken in Gutman is not part of the ratio of that case. What you find is certain observations by the Chancellor, which now have been picked up at the tribunal level as an approach that should be followed. Because to deal with my Lord Justice Zacaroli's point, if you go to those paragraphs in the tribunal judgment that I referred to, it is fairly clear, in my submission, the tribunal is taking the view, following Gutman, that it's better off, one's better off leaving this all to the end of the case, unless there's some reason, as you'll see, to look at it at the gatekeeping stage. And my submission will be is to the extent that that is something to be deduced, first, it is not part of the ratio of Gutman, and I will turn to it in just a few minutes. And secondly, it's back to front. It shouldn't be that way. And that is something on which this Court of Appeal, looking at the problem directly, because it wasn't looked at directly in Gutman, can give very useful and very current guidance. The point, essentially, is that from the point of view of the well-functioning of this system, the nub of the concern is that the approach which is followed by the tribunal, the presumption, at the very least, that one goes to the end of the day, materially increases the risk that's faced by litigation funders. Thereby, it's apt to increase the cost of funding, generally, which is a bad thing for the regime, and even, as they say, to putting off funders in this area altogether, and that undermines the system. So now, with your Lordship's steer, I'll turn to put a little bit more clothing on the issue whether there is.
I mean, you say, your concern for funders is touching, but I go back to my first point. I think you are going to have to relate it a little bit more for me as to what practical implications it would have for a defendant in this sort of situation. I know you say, well, if we don't raise it, nobody else will. I mean, in a sense, the CAT itself will always have to consider the funding and always has the opportunity to consider funding arrangements in discussion with the class representative. It's a peculiar feature of these cases that you, the defendant, seem to be carrying the torch for the poor old funders. Is that right?
Not entirely,
No,
my lord. No,
I didn't
with my
think,
permission.
I was being a little bit...
No. But the first point, and it was just drawn to my attention by those behind me, which I'm grateful. There is precedent for this. In the Gormson case, it was an earlier case which is referred to in these authorities, the tribunal expressly said it was grateful to the defendant there, Meta, for raising these points about the funding, which led to the points that we're about to see.
I mean,
so that's by way of
I've sat on
context.
enough carriage dispute appeals now to know that, you know, there are lots of what might appear perverse sort of incentives for defendants to argue about all sorts of features of you know, who sues them and on what basis. This is just a very particular manifestation of it, but I think we do need to understand as part of your overall contention that there was an error of law in what the CAT did, that you should address why it matters to a defendant.
I'll address why there's an error of law. So far as why it matters to the defendant is concerned, at this point I'll simply underscore what I was saying earlier. If one takes, for example, the perverse incentives point.
You're going to develop those and just identify them, certainly.
Yes, but if one takes the perverse incentives point, that is something which obviously is going to affect the defendant in the way that the proceedings are conducted, and it has an interest in the way that they are conducted, and therefore the potential outcome that it faces.
Yeah, okay. You'll have to identify what the perverse incentives are to make that good.
Yes, I'll do that.
Yep.
So, if I may then, I'll take your lordship's steer and start with Gutman and Apple.
Yeah.
I'll look at that and the discussion of funding issues and the legal framework in the judgment of Sir Julian Flow. Then I'll turn to the points made by Amazon to the tribunal in this case, so you can see what was said about these matters that was troubling the lordship. And finally, I'll show you the way that the tribunal dealt in its judgment with these points and with the issue of funding, and expand a little on the points that were debated with my Lord Justice Zacaroli in a moment.
And keep your eye on the clock, please.
Keep my eye on the clock. So if we turn up Gutman and Apple, that's in the authorities bundle, tab 2, page 8. The introduction is paragraphs 1 and 2. That tells you what the focus of the case was. You see from paragraph 1 that the appeal was in respect of a judgment of the CAT concerning funding issues there. The Chancellor points out there were two live grounds, grounds 2 and 3. He describes them in paragraph 2 of the judgment. And you'll immediately see that neither of them is precisely on point for present purposes. The first of those concerned the powers of the CAT at the end of the proceedings to make an order that the funder's fee be paid out of the damages award in priority to the class. The second contends that the legal funding agreement in that particular case created sufficiently perverse incentives that the CAT should not have authorised the class representative. And again, by way of observation, you'll note that Apple is obviously the active litigant here at the Court of Appeal as well. In paragraphs 5 to 9 of the judgment, the Chancellor brought together a number of key observations about the place of litigation funding in these types of cases and the considerations that should be taken into account by the tribunal. But this is by way of context. It is not part of the ratio of the case addressing those grounds. If you go to the top of bundle page 9, which is internal page 4, you'll see that he quotes an extract from Lord Justice Green's judgment in the earlier Gutman case from 2022. And focusing on what Lord Justice Green said there are three main points. The first one, about 6 lines down, is that the tribunal must recognise the importance of litigation funding for mass consumer actions and the need to attend to the ability of funders to seek a legitimate return on investment. Second point, on the other hand, the risk that this brings of disproportionately high costs. Third point, distinctly, the risk highlighted in Canadian literature that funders have an incentive not aligned with the class to sue and settle quickly for sums materially less than the likely final award. The following paragraph 6, the Chancellor notes that since the Packard ruling in the Supreme Court, clarifying that it's impermissible for funders to be paid a simple percentage of return to the class, you have litigation agreements in place where returns are, he says, they're linked to multiples of the initial outlay. That leads to the so-called perverse incentive on the funder to strike an early settlement for modest damages. Pausing there, I must add that the same holds true for other kinds of arrangement where the funder's returns are not tied to the returns to the claimant class, such as agreements exactly like the one in this case, where, among other things, and I'll show you this, the funder gets huge cash sums when certain litigation milestones are hit, like exchange of disclosure lists. Paragraph 7 is important. The Chancellor points out there are safeguards built into the legal framework to counter those risks, and he refers to two of them. The first is that a class representative will negotiate an appropriate and competitive funding agreement at the start of the case. The second, which you'll see mentioned in the second sentence of paragraph 7, is the fact of the certification stage itself, the filter. This is where the tribunal's the gatekeeper. The Chancellor says that as part of certification, the tribunal will consider the proposed funding arrangements. And then, having said that, at the foot of page 9, bundle page 9, the Chancellor refers to the judgment of the tribunal below, quoting from the earlier decision in Gormson and Mehta, 2024. And that if you go to the top of bundle page 10, looking about 4 lines down in the quoted text, the Gormson Tribunal says, at certification, the tribunal should not generally carry out a review of the commercial arrangements reached with the funder. And why is that? Apparently because of the need for the tribunal to recognise the considerable financial risk that the funders undertake. And instead, according to the tribunal chair there, which is, I believe, Sir Marcus Smith, the return to the funder is generally to be controlled on settlement or judgment, although there do come points when funding arrangements contain provisions sufficiently extreme to warrant calling out at certification or to warrant a blanket refusal to certify. So there you see an approach laid out, which is generally leave it to the end, but if something extreme occurs, then you can call it out, whatever exactly that means, or refuse to certify. And that is why I say there's a particular approach which you see there. 2 immediate observations on it, because this is the passage that's likely the tribunal, in our case, we say understood as showing what the Court of Appeal in Gutman was saying when it referred to an approach authoritatively set out. The first is that this is not part of the ratio of the Court of Appeal in the Gutman case, Gutman and Apple. As I say, it doesn't go to either of the 2 live grounds of appeal. It's a record of the position taken by the tribunal below without a specific comment by Sir Julian Flo, and it is not a matter on which there was any argument. The second point is that as the submissions to the department by the Legal Finance Association and the Class Representative Network both expose, the logic is very questionable, because the CAT's concern is to avoid putting off funders, on whom the regime depends, from taking the considerable financial risk of providing funding. But there isn't, when one thinks about it for a second, mitigation of the funder's risk by leaving the issue of acceptable funding over until a decision at the very end of the case. The result of doing that approach, is to raise risk, not reduce it, because funders are less likely to invest in claims if the default approach, if the presumption is to defer the decision whether to cut down returns in the event of success until you've sunk large amounts of money into the litigation over a period of years. And then the final point to take from Gutman and Apple is in paragraph 9. There you do have a better reason for considering the funder's fee at the end of the case. And it applies in some, but critically, not all cases. The Chancellor refers there, paragraph 9, to an observation by the tribunal below that at the end of the proceedings it may, I emphasise may, have better visibility as to the proportionality of the funder's fee in relation to the damages awarded. And it can, if necessary, require further evidence. That is the sum total, as we see it, of the points, and I've dealt with it very quickly, to take from Gutman and Apple in the Court of Appeal and its status. If you would now please put it away and pick up the supplementary bundle, I'll follow my Lord Justice Snowden's suggestion and show you the key elements of the position in this case by looking at the submissions on funding advanced on behalf of Amazon at the certification hearing in this case. So you find that in the supplementary bundle at tab 4. I hope you have that. There are essentially 3 points made.
This is a transcript we're hearing.
It's a transcript,
Yep.
Yes, you should have a transcript. Yep. And it's days 2 and 3 of the transcript.
Yep.
2 extracts.
Yep.
Essentially 3 points are there. The first is that the levels of the returns envisaged in the funding agreement here were extremely high. The returns were at levels which even on the PCR's case, the class representatives case, were previously treated by the tribunal as indefensible and which did necessitate calling out. And in the interest of speed, if you go to bundle page 63, which is internal page 8, you see that in lines 15 to 24, where the detail is set out. Particularly if you go lines 21 to 24, we consider that part of the calculation is wrong. If you take it on its own terms, it's in the same territory as the 8.3 times level, which the tribunal president in Gormson described in withering terms as not defensible and sufficiently extreme to call out. This isn't questioned. Indeed, the tribunal records in its judgment that it does see potentially exceptional returns. The second submission is the perverse incentives point. Important and independent. You move from level to structure.
Sorry, you say that the cat in the instant case, our case we're currently looking at, essentially said that the current situation contained an extreme level of return, is that right?
Yes, what they said was that it was potentially indefensible.
Potentially.
Potentially extreme. Let me find the...
It's paragraph 67.2, isn't it?
It's paragraph 67.2. We do find it could potentially result in an exceptionally high return. That was their summary following these submissions that you see here.
So it's not as if they were unaware of that.
No, they were absolutely aware of it. And in my submission, particularly because they were aware of it and they did flag it up, to then say that one simply puts this off to the end of the case and follows the approach, which they say was authoritatively set out in Gutman, is insupportable, and that is a legal error in its own right. But I move from that to the question of from level to structure. The second submission was that the structure of the agreed payments generates these perverse incentives by setting up a series of milestones after which you achieve a jackpot, if you're the funder, if there's a quick settlement. And to see what the facts and evidence were on the same page, if you still have that open, 63, just look up at lines 1 to 14, referring to the fact that there were these huge stepped payments which rise on certain litigation events. If you just look at lines 12 to 14, if this case was to settle shortly after disclosure, exchange of lists,
Which page
understands to get more.
I'm sorry, which page are we on?
You should be on, within the supplemental,
Yes.
page 63.
63, right, sorry. Yeah.
So it's the one we were on before.
Yep.
So I've just gone higher up the page, and lines 1 to 14
Yep.
are here's dealing with the perverse incentives and the structure points. And if you look, cast your eye over that, you see the detail and a point made in lines 12 to 14. If the case settles shortly after disclosure, the funder gets more than 20 times the money it's actually hazarding. So it has certain sweet spots, and this is different from the interests of the class representative. So what we did was identify very clearly what are called perverse incentives operating in this case. And for the general submission on perverse incentives, it's probably good to look back at page 58 of the bundle. And if you just go to the very bottom line, line 26, the defining feature, as was canvassed a few moments ago, is large step changes in payments of a huge amount at various intervals. One thing this unusual structure in this context does create is perverse incentives on the funder at each stage to delay the settlement until after a milestone has been reached and the jackpot is achieved. At all events, you can see that this is the point that was made and was placed before the tribunal. The perverse incentives, to pick up what I was saying at the outset, work their effect.
Why is it not possible for the class representative to raise those points?
The class representative's incentive here was to get through on certification and to proceed to trial with the minimum of fuss. So it is in the posture, typically in these cases, in all of these cases, of defending the arrangements that are made rather than raising them as problems so that it goes back to square one or faces a refusal to certify. The natural litigation momentum will always be for the proposed class representative not to say to the tribunal we have a problem, but to seek to minimise that, and it will be on the defendant in all of these cases as the natural dynamic to raise these points.
Right, so you're complaining that the person suing you has a perverse incentive to settle with you.
Well, we have a complaint that the person suing us has a perverse incentive to seek to reach a settlement at certain points, yes. When you say to settle with us, it's not merely to settle with us, it's in order to achieve certain ends, which may be to our disadvantage depending on the way that the case is structured. It certainly does affect the defendant. You can't say that it is something which is of no interest to the defendant at all, which it has no interest in bringing before the court or here the tribunal. It is something which only the defendant will raise for the reasons I've given, and where the points do need to be considered in the interest of the health of the system. Now, to complete the point on this, these perverse incentives do work their effects through the currency of the proceedings. It follows that by the time the proceedings have come to an end, and you're looking at it retrospectively, they have had those effects. So simply saying it will be dealt with at the end is not going to address that.
So you not have to look at this together with paragraphs 54 and 55 of the judgment, where the issues around settlement was expressly considered, and the provisions in the agreement which relate to if there is dispute between the funder and the PCR, then it can go to a dispute resolution by a KC. So that and the CAT found that those provisions were satisfactory. So isn't that where this point was addressed?
This was not. This point was not considered in that context. It's true that those provisions were set out, and one may then raise an argument that that will take care of this problem. It will not, however, prevent the fact that these perverse incentives are operating and will lead to these
doesn't
tensions.
it? I mean, the point about the point about having those provisions, isn't it, is to cater for the possibility of perverse incentives on the funder, which will, in any case where you have a funder, whatever the arrangements are, there may be times when the funder's interests diverge from those of the person it's funding. However extensive the funding is, it's always a possibility, isn't
It is always a possibility. Here, what was drawn to the tribunal's attention was the very sharp perverse incentives that arise, and what you do not have in the judgment. You're absolutely right, my lord, that you see a recitation of those provisions. You do not see any conclusion that this point was drawn to our attention, that we see that these arrangements are going to be satisfactory to deal with this point, and the observations that were made about the way the perverse incentives will arise and have their effects in this case.
There are differences of incentives between the funder and the person funded. That's what the settlement provisions deal with. So the tribunal addressed those and said we're satisfied with those. Why does it make any difference that the particular incentive on this funder might be even greater? Because however much it's incentivized, it's still got to fall within these provisions, hasn't it?
Because it does have to fall within these provisions. There will, however, be these disputes, and the sharper the divergence between the incentives of the class and the incentives of the funding group, the more these tensions are likely to arise. One can refer to these provisions as in existence, but to make the assumption that they are going to deal with the problem of perverse incentives is first not stated by the tribunal, obviously. It's an inference that my lord is drawing. And secondly, we say is not going to satisfactorily deal with the operation of perverse incentives in any case.
But at the time, at the end of the proceedings, by definition, you will have settled.
Yes.
Or been found liable for this to arise.
Yes.
So you're not going to be involved at that stage anyway.
Yes, the defendant is not going to be involved at that stage. It will, however, be approached.
But so, by definition, you will have entered into an agreement, a settlement agreement, which you found satisfactory.
Yes, the defendant will, at that point, have done so.
And there was either a prior dispute resolution mechanism between the interested parties, the class rep and the funder, or alternatively, the CAT will be able to address the question in light of the experience between the parties that are actually interested in the question at that time.
My lord, turn it round. What about in the case of an award that is made by the tribunal at the end of the day as well?
Okay, but then the perverse incentives to settle that you've identified won't have kicked in, because by definition you'll have run it to its end and you'll have lost by a decision.
Yes, no, my lord, no, I see that. We're dealing with the case of settlement and the fact that during the currency of the proceedings there will be internal tensions within the claimant's camp, which will mean that decisions will be made to approach the defendant with certain offers at certain times.
Yeah, and if you're not happy with them because they've been driven by a perverse incentive, then you just say no. Or you can use the perverse incentive to your own benefit in settlement negotiations.
My lord, that is correct. At all events, the operation of it in this way means that the defendant, the way that the proceedings progress and the way that the defendant conducts itself is necessarily going to be affected by the nature of the funding arrangements that are in place.
Okay.
So may I turn to the third point, with an eye on the clock. The problem with leaving the matter of funding unresolved until the end of the proceedings in this case were the subject of argument, and I'm going to draw your attention for present purposes just to one of the points. In the submissions, if you go to page 65 of that transcript in the supplemental bundle, which is internal page 10, starting at line 18, and this goes, if you read down to the following page, it's sidelined down to line 20. To summarise, this is the point that in this case, the litigation funding agreement was struck at a specific transitory time when no other funder was prepared to make a competing offer. So, an unusual situation. There was no competitive process whatsoever. Those were adverse circumstances affecting the agreement. Those adverse circumstances disappear once Hammond has won the carriage dispute against a rival, which occurred 15 months before this certification hearing. Then at the time of the certification hearing, there's no reason to believe that true competitive terms in the market are not available, because those conditions no longer apply. That point was the third point that was made to the tribunal as to why, operating as an essential safeguard, you now do not have a situation where, coming back to what the Chancellor said in Gutman and Apple, it can be assumed that the class representative will have negotiated an appropriate and competitive settlement. If you now go back, please, to the core bundle to look at the tribunal's judgment in this case, I'll finish by running through the salient points. You go to tab 4. The relevant discussion of funding begins on bundle page 54. Runs from paragraph 48 through to 69. Amazon submissions are dealt with from paragraph 59 on page 57. The tribunal refers to what's been put to it. Those three issues are the ones that I've shown you. It does not deal with or record the submission about the need to counter the effect of the perverse incentives during the currency of the case, other than potentially in the way that my Lord Justice Zacaroli has referred to. Second, it does not address the point about the need, in view of the manifest indefensible returns, to address the matter at certification in the interests of clarity for the litigation funder, one of the key principles that had been referred to by the Chancellor in Gutman and Apple. On the contrary, as my Lord Justice Zacaroli says in paragraph 67(2) on page 60, the tribunal instead makes a specific finding that the agreement could potentially result in an exceptionally high return and leaves the matter hanging until the end of the proceedings. That, we say, is insupportable. And third, it does not deal, the tribunal, with the point that since these agreed funding terms were admittedly uncompetitive, not the result of competitive bargaining, because there was only a single offer, but competitive market conditions do now exist, there is good reason to direct that competitive terms protecting the class's interests should be ascertained now. Those are each elements which you do not find dealt with in the reasoning here. As to the positive elements of the reasoning, the tribunal does say at 64, return to the first point, that scrutinising the funder's fee only at the end of the proceedings is in line with the approach authoritatively set out by the court in Gutman. And to summarise again, that is at the very least the presumption that one deals with this at the end, and only if there is something extreme does one go into it at the certification point. That is the point of approach that we seek to raise. The tribunal also holds at paragraph 66 on page 59 that at the end of the proceedings it will be better informed. And this is where it cites the Australian federal judgment that wasn't canvassed with the parties at the hearing, money max, and on which we will want to make submissions if permission is given. The tribunal also overlooks the point that in the circumstances of this case, there was the one vital respect in which the tribunal will not be better informed at the end of the case. As I've said, the question what competitive funding terms are available now.
I mean, the CAT, 2 points. First of all, in 67.1, the CAT does clearly have in mind the need to have what it calls favourable funding terms. And it does note clearly the point in time at which the funding arrangement was negotiated. So, I mean, it's not that the CAT didn't have it in mind.
Well, my lord, that's a point that was. I'm grateful to you for raising it. That's a point that is specifically raised in our skeleton. What they do in that very paragraph is to say they wish to be satisfied that the PCR has made proper efforts to secure favourable funding terms, then records simply what they were told, that at the time there wasn't another offer, it was harder to secure funding, and then that's it. So that is not, in my submission, dealing with the point that they should have addressed, which is, are they satisfied that there was an attempt to get the competitive funding terms? On the contrary, it merely records that at the time...
Yeah, but you can't say they didn't have it in mind. They say, we do have it in mind, we've had an explanation, we did raise it, we've had an explanation, and in the exercise of our discretion, we think we can deal with this at the end of the day, because that's what they go on to say in 67.2.
But if the...
is that an error of law?
Well, yes, because we say if the explanation that's given, so he raises the point, proper efforts to secure favourable funding, which is slightly different from satisfying oneself that there was, in the Chancellor's words, appropriate and competitive funding. It's different. It doesn't address the question whether there was competitive funding. On the contrary, it merely records that in this case, there weren't any people available to give competing offers at the time because of the peculiar circumstances, and leaves it there. So my submission would be that first, it is not addressing the point that the Chancellor had flagged up about the need for the safeguard to operate by seeking competitive terms. And secondly, that on its own terms, merely to say that we received a witness statement to say it was all very difficult, does not show that there are these proper efforts that have been made by the time of certification.
The tribunal did come back to this in their permission to appeal reasons, 15 and 16.
Yes, let's, if we turn to that.
And essentially it said, well, yes, we see the point, but it would cause yet further delay. So they seem to be impressed in terms of balancing the factors by the delay that would cause.
Yes, I'm grateful, my lord. That was the point I was just going to come on to at the end. That's the final point. If we turn to that, it's the last tab, tab 5. You're quite right, paragraphs 15 to 17. The point is addressed really in 16 and 17. Two observations. The first is, this is an addition to the reasoning in the judgment. It is a gloss on it. These aren't points that were made in the judgment itself. And second, as your lordship says, by way of content, the tribunal says we made a choice to avoid delay by putting off the question of unreasonable funding terms until the end of the case. And that's unsatisfactory, and it's related to the fact that it shouldn't be raised post-judgment in this way, because it's an ex-post justification. There is no picture of the size or significance of the delay that would actually be caused, because that was never explored with the parties. It may not be a weighty factor at all. To be raised in an ex-post fashion in this way, without consideration, we'd say is unsatisfactory and should not be given weight. It was a point that was not properly addressed, therefore. And so, my lord, for those reasons, we respectfully submit this is a ground of appeal, standing back, that is well arguable. It does raise a question of law, because I hope that I have shown your lordships that what I am attacking is the approach that was taken by the tribunal, the fundamental approach to these cases, which is essentially a very great momentum to leaving these matters over to the end of the day, unless there is something, at the very least, sufficiently extreme. But that in the circumstances of this case, there were matters that were not attended to. And if I stay with the last of those points in particular, this issue that there weren't competitive terms at the outset was raised. It was not dealt with in the judgment. The way that it is finally addressed, as my Lord Justice Zacaroli rightly says, you see in the ex post discussion by way of gloss. And at that point, if the tribunal is saying, well, we balance that against delay, it has not looked into or canvassed with the parties what that would actually mean. It's not an appropriate or satisfactory approach to take. What we would wish to raise, if this matter is considered by the full court, is essentially the question of the approach that is taken by the tribunal in this sort of case. This litigation and this particular case has certain features that make it very suitable to be raised because the tribunal did not, as I say, grapple with these points.
Okay. 2, possibly 3 quick questions from me.
Yes.
In paragraph 64 of the judgment, you hang, I think, quite a lot on the words "at the end of the day." Is it possible to read that simply as it's not actually saying it should be dealt with, quotes, at the end of the hearing? It's just at the end of the day, it's saying, you know, in any event, the amount of the funders for your return. It's not actually setting out a view that it should be dealt with at the end of the day. It's just saying it can be. And that is what actually Gutman says.
Yes. I'm grateful. We say no, and what I would do is really just to pull together the points that I was making earlier when you adumbrated this. When you read this together with the Permission to Appeal ruling, in my submission it is clear that what is meant is that the right approach to follow, the default approach to follow, according to the tribunal, which they regard as the approach now authoritatively set out by the Court of Appeal in Gutman and Apple, is that you leave the matter to be considered at the end of the day, in the sense of at the end of the proceedings.
Yes. Okay. Well,
And the reason for that, I mean, if you go to paragraph 66.
I was going to say, I think 66 is probably your better point, you say, where they do raise some other arguments, but I just wanted to go back to those words. Number 2.
Yes.
Compelling reason. If we were against you on the question of law, whether there's an error of law here, you say it's a compelling reason anyway because there's been a call for evidence. Why wouldn't it be better just to leave it to see what comes out of the call for evidence? Why does this court have to stick its oar in?
Because
where it ex hypothesi will have found that the tribunal didn't go wrong as a matter of law.
Because there are these 2 approaches that can be taken, but they are not essentially the same ways of solving the problem presented by this sort of situation.
But if
the primary way to approach this is to look at the way that the court, the tribunal, deals with these points. That is the matter of complaint by these associations. They raise it on the basis of very significant policy concerns which are readily understandable. The point that I have raised is to show you that the thinking at the start of this, which originated in the Gormson case, that by putting things off until
sorry,
the end.
I need to just speed you up a bit, because
Yeah.
my simple point is, as I understood it, your submission was, even if we couldn't see that there was an arguable error of law in what the CAT had done here, there was a compelling reason to grant permission to appeal so the Court of Appeal could give definitive guidance on the way this should be approached in these type of cases.
Yes.
So assume that you've got no arguable error of law. Why should the Court of Appeal stick its oar in circumstances where you've just shown us there is a public exercise going on
Yes.
to take a wider view of litigation funding in this particular type of case? Why should this court stick its oar in?
Because it's not sticking its oar in. It is the primary approach. The complaint by those associations is one directed at a change in the law, legislation being introduced, which is the fallback where the system is not working properly. The primary way of addressing this, the right way of addressing it, is for the tribunal, the Court of Appeal, to lay down how the approach should be addressed.
In a case where ex hypothesi, we would have taken the view that it's not arguable that the cat went wrong.
The approach would be the approach that was taken by the tribunal, if it is a matter of real significance, should be considered by the court. The rules, obviously, in the way that they're structured, either well arguable real prospects for success or some other compelling reason, obviously admit of a case where, even though something is not well arguable, if there is a compelling reason, it should be looked at. Here in my submission, you have a paradigm case where there is a matter of general approach where this court, I hope, can see that there is a real issue of approach at stake, which therefore it would be sensible for the full court to consider, and that the background prospect of a legislative solution is not the answer.
Okay. Right. Thank you very much. Yeah, I mean, I think, can we hear whether, Mr. Raymond, you want to add anything briefly in response, since you are here?
Well, my Lord, I'm very grateful, and I am very conscious of the time. It seems to me that what may be helpful is just to, and it may be taken for granted, I don't know, but it's always dangerous to take things for granted, is it may be helpful just to focus on the test in Rule 78, which is the test for authorization of a class representative. I mean, you have that in tab 1 of the authorities bundle. I don't know if you find it helpful to go to it. I mean, the essence of it, and I can summarize it very, very, very easily, is Rule 78 essentially requires a broad-based judgment by the Competition Appeal Tribunal as to whether it's just and reasonable for Mr. Hammond to act as the class representative. And although Rule 78 mentions various specific factors, the issue really boils down to whether, pursuant to Rule 78(2)(a), Mr. Hammond would fairly and adequately act in the interests of the class members. And you, my Lord, and my Lord Justice Zacaroli had an exchange with Mr. Turner about the various provisions of the funding arrangement that were analysed very carefully in my submission by the tribunal in the judgment, including governing the control of the proceedings, ensuring that the control of the proceedings is in the hands of the class representative, not the funder, making provision for the class representative to act adequately and fairly in the interests of the class at settlement, matters like that. And really, there was a question of my Lord Justice Zacaroli was putting to Mr. Turner, well, wasn't that the answer to the perverse incentive point? And absolutely it was. And it was, and the way that one needs to look at it is through the lens of the test, which is, is there something in the whole package of measures, including the funding, that the class representative has assembled to bring the case on behalf of the class members? Does it enable him to fairly and adequately act in the interests of the class members? And the reason the tribunal was analysing all of those matters so carefully was that it wanted to make sure that even if there was any perverse incentives between the funder and the class, which in the post-PACAR world is something that is somewhat inherent, the really important issue in the context of the test under Rule 78 is whether that actually affects whether the potential conflict of interest, the potential for which is always there between the funder and the class, whether that is going to affect the ability of the class representative to bring the action on behalf of the class fairly and adequately. And in my respectful submission, the tribunal asked itself the right question, and the conclusion it came to is unimpeachable in this context, because there is, contrary to what Mr. Turner valiantly strove to persuade you, there is no real issue of law here. It's quite clear that the Competition Appeal Tribunal has a very broad jurisdiction and supervisory powers over the class representative, including over the funding arrangements, and in particular when to deal with the funding arrangements and in how much detail. I mean, it's all within the discretion of the tribunal. This is not, if there is any error of law in this case, it has to be a rationality challenge in my submission, whether that's relevant or irrelevant consideration being taken into account, or the exercise of the discretion more generally. This is a rationality challenge, and Mr. Turner doesn't get anywhere near to showing that there's an arguable case on rationality. The most that he gets to, certainly in his skeleton, is suggesting that there was some kind of rule that the Competition Appeal Tribunal applied based on Gutman, and to some extent thereby fettered its discretion. And I mean, at various times he called it the default rule, but it's not. In my submission, that there is just a discretion, and the CAT did not, at any stage, suggest in its analysis that it was applying a rule that it had to deal with the funding arrangements at the end of the case.
Right.
Unless I can assist you further. I mean,
Thank you very much.
Your Lordship's asked a number of very pertinent questions, and if I had more time, I'd be very happy to engage. But if I can't assist you further, I will.
No, thank you very much. Right, well, we are an hour and a quarter in. We'll move on to the Stephan application. I think you can assume, Ms. Lakova, that you don't need to try and finish it in the next quarter of an hour. I think I was over-optimistic. But we will most definitely finish the application this morning. So there's no question of going anywhere beyond 1 o'clock, and I'd certainly want to try and finish it, in fact, by about 1:45.
Understood, my lord.
Right.
So I say that the legal issue in this appeal is whether a class representative, who everyone agrees is a fiduciary,
Yep.
Can properly act as a class representative, where some of his decisions in respect of a key measure will favour some members of the class to the detriment of others.
Right, now just pausing there, and I'll just try and give you a steer, and it may well be that Mr. Carroll Green will hear this, because it may be that he will have to do a bit of heavy lifting in a minute or two. I think we both want to try and understand the case theory as to how the various heads of damages are said to arise from the wrongs that are said to have occurred. Now, I appreciate it's not your case, but nonetheless, do you want to have a go first up at what you understand? Because that very point about the effect on one group of people of behaviour in relation to another is where we are both struggling, I think.
No, absolutely, my lord. So if I may, I was just going to set it up by referring to a small number of factual background factors, because that's what then makes sense out of the rest of it. That will only take about 15 seconds. And just to take a quick step back, as your lordships will appreciate, there are 5 alleged abuses in Professor Stephan's claim.
Yep.
For the purposes of this appeal, we are only concerned with alleged abuses 3 and 4,
Yep.
because that is where the alleged sales diversion arises. So we can forget for today about alleged abuses 1, 2, and 5.
Yep.
So focusing first of all on abuse 3, because that is the more straightforward illustration of the conflict, I say. And in terms of the background facts to bear in mind, so first of all, of course, the allegations concern the Amazon UK store. Amazon itself offers some products, but it has also opened up the store to third-party sellers. And then on an offer-by-offer basis, third-party sellers then have 2 options in respect of each offer. So one, either they use Amazon's fulfillment network. So in that case, their inventory is stored in Amazon fulfillment centers and then shipped by Amazon Or then two, alternatively, they can use what is referred to in the judgment below as FBM. Now, that is not a term that Amazon normally uses, but I will adopt it to avoid confusion. And that's short for fulfillment by merchant. And what that means broadly is that the third-party seller makes their own fulfillment and shipping arrangements. They might outsource it, but in any event, they are responsible for them. Now, alleged abuse 3 then is all about the allegation that Amazon favoured FBA offers over FBM offers. And I will go straight to the effects because I understand that's the core concern. And we can have a look at how Professor Stephan himself summarises it as well. I can cross-refer to that. So there's a neat summary in the Stephan reply. That's in the supplemental bundle, tab 9. Page 172. Sorry, it's actually page 173. And so, first of all, there is what we have been referring to this in our skeleton as either the direct effect or the cell diversion rate. And so that is the allegation that the alleged preference.
Sorry, I think I've not got the right
I'm sorry, it's
bundle. It's
supplemental, tab 9, page 173.
Yeah, it's the Stephan supplemental. I'm just trying to find. Just give me a
I
second.
see. Oh, I see.
Okay. I'm not sure I can find it electronically at just this instant. So, yep.
Is it the paper page 173 you're after?
It's page 173 of the bundle, and it's page 61 of the reply. And this is Professor Stephan's reply.
Yeah.
So first of all, the direct effect, and that is the allegation that sellers using FBM lost sales to sellers using FBA. And we can see that recorded in paragraph 106.1, where Professor Stephan says, first, sellers sustain losses in retail markets.
Okay, that I understand.
Very
Fairly
well. And then
clearly.
on to what we refer to as indirect effects then. Then Professor Stephan alleges that as a result of this sales diversion from FBM to FBA, there's three effects. So first of all, he says that the FBA fulfillment fees became higher due to the increased demand. So because FBA offers are favoured, he says, therefore FBA gets more offers to deliver and to process, and the fees have therefore increased. And this is what we've sometimes referred to as the FBA overcharge. And that is mentioned in paragraph 106.2, which is where in the second sentence he says that the favouring of FBA sellers in the buy box and for Prime led to higher prices for FBA services, brackets, due to increased demand.
So it's not just that they got more because there were more people using the service. The actual cost of the individual use of the service went up.
That is the theory. So that's the first indirect effect. Then there's the second alleged indirect effect, which is that the FBM fulfillment fees were higher as a result of the alleged abuse. So FBM fulfillment fees meaning what, for example, Royal Mail might be charging FBM, sellers making FBM offers in respect of deliveries and so on. And the theory behind that, well, the allegation is that third-party logistics providers were prevented from achieving scale because of the sales that they've missed out on, or in their case, more precisely, because of the deliveries that they've missed out on.
So, is this right that the FBM merchants would not sell, but would pay higher fees for the sales that they did, for the reduced number of sales that they did achieve?
Sorry, could you?
So more sales get diverted to FBA fulfilled by Amazon.
Yes, that's the answer.
So from an FBM merchant's point of view, somebody who's trying to sell FBM, they don't, number one, they don't achieve as many sales.
They lose sales, yes.
They lose sales, but that's not claimed.
That's not it? Sorry.
That's not claimed.
So Professor Stephan would say that that is claimed in the sense that that is part of his case. But then the way this works, the way he expects it to work, is that because step one in these proceedings is to assess damages on an aggregate basis, so what this class of sellers as a whole lose as a whole, the sales cancel each other out. That I would say already gives us an indication as to where the conflict is. So he says he's claiming in respect of these lost sales, but he isn't proposing to quantify this, except in some marginal circumstances, because he recognises and pleads that actually the sales that were lost, the FBM sales that were lost, went to FBA sellers. Again, I say sellers, it's not entirely precise in that obviously people can sell using either or both, but and therefore the two cancel each other out, and that is a part of his pleading case. And so we can see where, well, in some ways that is in fact one of the clearest manifestations of the conflict, because
Well, is it because the claim is for the increased fees, whether it was an FBA or FBM sale? So even there may well have been a diversion from FBM to FBA. So in the counterfactual, you reverse that. But so what? Because the claim is because of the increase in FBAs, everyone's fees were increased, and that's all that's being claimed.
Yeah, but I think I'm sorry to cut across my law for a second. He's right, but I think you said that in the claim, the actual loss of sales is part of the claim in respect to the loss of sales by the FBM merchants from whom business was diverted, but it said that that's cancelled out for the class as a whole, consisting of FBM and FBA, because of the increase of sales, the concomitant increase of sales for the FBA merchants.
the gained sales, yes, so the gained sales by FBA sellers cancel out.
So
on the
does
net.
that mean that if I was only an FBM, I would have suffered loss because I would have lost sales to somebody who was an FBA merchant, but this class isn't going to help me recover those because the person who got my sale is one of my class members, and my class rep isn't going to be therefore claiming for the class as a whole anything that will help me?
That isn't quite how Amazon puts it. So the way we put it is that someone at some point is going to bear the brunt of these decisions. So it could be, and we accept that it could be the case, that this goes on to the distribution stage after the initial aggregate damages assessment stage. And it's theoretically possible that at that point, all of the aggregate damages, if any, just get split up between sellers.
But if
without
the
regard
aggregate
to this.
if the aggregate damages are only computed on the basis of the loss of fees, which is where my order is coming in, or increased fees, then there's no element for the actual loss of profit on sales.
Precisely. That's precisely the point. So if that is what happens, then FBM sellers, again I say broadly, miss out, and they are disadvantaged by virtue of how this
All
claim
right.
is being
Well,
run.
well, we've identified at least a point that Mr. Carroll Green may want to help us on. But okay. But now we'll go to the fees now, the increase in fees, which is what your paragraph in your skeleton.
Sorry, just so I can keep up with this.
Sorry.
So they lose out because a claim is not being made for damages flowing from their lost sale. Is that the point?
They may lose out if that is how it ends up transpiring. There's an
No,
alternative.
but that's a given, isn't it? There isn't a separate claim here for loss flowing from lost sale.
That is entirely right. But there is a scenario in which case in which they may not necessarily lose out, which is this. If once there's an aggregate amount of damages and then we move on to distribution, at that point, it is also possible that these differences between members of the class get taken into account. So at that point, it is perfectly possible that FBM sellers would get more of the aggregate damages by virtue of the fact that they had also missed out on sales on Professor Stephan.
But that's only because, but the aggregate damages are not computed on the loss of profits. Because
no,
because that's been wiped out by the fact that there are extra profits made by other members of the class.
There's
the
a very
FBA.
there's a very important second aspect of what I was going to say, which is if that is how damages were to be distributed, in that case it is the FBA sellers who bear the brunt of the decisions in respect of the diversion rate, because anything that comes out of the aggregate damages award for the benefit of FBM sellers necessarily has to be to the detriment of FBA sellers, because someone has to lose out. As observed, my lord, as you have observed, it is not being quantified, the loss in respect of these lost sales, and therefore someone has to lose out at some point.
Yep.
And one of my core points is either going to be the FBA sellers who lose out, or it is going to be the FBM sellers. But either way, there is a conflict. And then to pick up the other question that I think I was being asked is, what about the overcharges?
Yep.
So of course there are the overcharges, and Professor Stephan emphasises that that is where these sellers are claiming their damages, and that it is in their interest for the overcharges to be as high as possible.
Well, the FBM overcharges would have to be as high as possible, because they're by definition overcharges on reduced numbers of sales. If you're an FBM merchant, your first complaint is I didn't get the sale at all.
Yes.
And so in a sense I wasn't overcharged on the sale I never got. But the complaint, as I understand it now, is that I will have been overcharged on the sales which I did get.
Yes.
I paid more, but on a reduced number of sales.
I paid more, but on a reduced number of sales. But that brings me to my other core point, which is that the way that Professor Stephan, based on his plea date case and based on his cases set out in the expert reports filed in support of his claim, he intends to measure these effects separately. So we can look at that. So first of all, how does he intend to measure the diversion rate? He still intends to measure the diversion rate, and we know that from his pleaded claim. And his expert, Dr. Hoopis, intends to run two methodologies. So first, he intends to rerun Amazon's algorithm to see what difference adjusting the criteria that Professor Stephan is complaining of would make. And that is how he intends to assess what the sales diversion rate is. And then second, in case that is impossible, he proposes to model the algorithm using econometrics. We don't need to worry too much about the detail of those proposed methodologies, but the point is that Professor Stephan is absolutely proposing to lead evidence on the issue of the sales diversion. So that sort of sits to one side. And then there's the question of, well, how does he propose to measure the indirect effects? And critically, does he propose to use the diversion rate identified by either of the two methodologies that I've just described as an input into that or not? And the answer is he does not. He does not propose to use it as an input. And so looking at the FBA overcharge first, so the alleged overcharge on FBA fulfillment fees, the way Dr. Hoopis proposes to measure that effect is by using a before and after method. So essentially what he intends to do is to compare FBA fees during the alleged infringement period with FBA fees in an earlier, we sometimes say clean period, so prior to the alleged abuse. And then while doing that, attempting to control for other factors that are unrelated, so oil prices, that sort of thing. And that is the methodology. And so Dr. Hoopis intends to measure direct and indirect effects separately and independently. And that is also the case in respect to the marketplace overcharge. In respect of that, he's also proposing to use a before and after method. And so what does that mean for the members?
And for FBM.
For FBM, he proposes to use a slightly different method, but which also doesn't use, it does not use the measured diversion rate as an input. He proposes to run surveys to work out what those fees at scale might have been, but he does not propose to use the measured diversion rate as an input. And so what does that mean for the members of the class? So as we know, the class will include may include third-party sellers who only use FBA. It may include third-party sellers who only use FBM, and it may include and will inevitably include third-party sellers who use both FBA and FBM. So looking at sellers who exclusively or predominantly use FBM first, now they can only benefit from every one of these measurements being as high as possible. So of course, as regards to sales diversion rate, the higher it is, the more sales they have lost. That can only be useful to them, for example, at distribution. And then similarly, the higher the overcharges on Amazon on logistics, by Amazon on logistics fees and marketplace fees, again, the worse off they have been as a result of the abuse. And so the key point is that they have nothing to lose from any of these measurements being as high as possible. That is what they would want. But then thinking about sellers who exclusively or predominantly used FBA, now they too would want the overcharges on fulfillment fees and marketplace fees to be as high as possible, of course. But that isn't the case for them in respect of the diversion rate. And that is, as has probably become clear from our discussions earlier, that is because the higher the measured diversion rate, the more sales they have gained as a result of the alleged abuse. And the more sales they have gained specifically at the expense of sellers using FBM. And in circumstances where Dr. Hoopers does not intend to use the measured diversion rate as an input when assessing the overcharges, there is just no upside to sellers who'd used exclusively or predominantly use FBA of the measured diversion rate increasing. Because looking at how this is being measured, the overcharge methodology will lead to a number, and that will be whatever that is based on the before and after method. But then the diversion rate methodology doesn't feed into that. And so in those circumstances, there's just no upside to them in the diversion rate increasing, because that just means that they've gained more sales in the factual on the application of that methodology. And so that brings me to where I say the tribunal went wrong.
So can I just pause there?
Yes.
So there are two stages to this. The first stage is to work out whether there was any overcharging, and that's the liability stage, as it were. Is Amazon required to pay anything to this class as a whole because the fees were raised when they shouldn't have been? And at that stage, the diversion rate is irrelevant.
Well,
It doesn't go. It may have been the expert may have worked out what it is, but then doesn't use it at all in working out what the overcharges were across the board.
Not necessarily, my lord. So the first point is that Professor Stephan will be leading evidence on this.
Well, I know, but you say he then doesn't use it at all when working out what the overcharges were.
He doesn't use it for that purpose, but Professor Stephan has also made it clear that it isn't necessarily the case that he will be relying entirely on the netting off approach either. So,
You mean the netting? Do you mean the netting off approach in relation to lost sales?
yes, and we can have a look at that, or I can just summarise it for now, and then we can see whether we want to look at that. But he's made it clear, well, Dr. Hoopis, Professor Stephan's expert, has made it clear in his third report in Hoopis 3 that there are at least two circumstances where he might, in fact, be quantifying these losses. So the first one is, he says, if and to the extent that the netting off approach is not appropriate, and then he gives an example, which is that if sellers who benefited from Amazon's conduct in relation to the self-preferencing of FBA are outside the class. So if they're a non-UK domiciled, for example, because this class only comprises UK domiciled sellers. So Dr. Hoopers himself says, well, in those circumstances, we may be quantifying that.
So
And
do you
then-
mean if there's an FBM, UK FBM member of the class, but it's thought they might have lost a sale to a non-member of the class, then they have a claim for lost profits. Is that it?
In a way, it won't be that specific because we will not be focusing on individual sellers, but in an aggregate sense, yes, absolutely. But that's the logic behind it. So if there are FBM sellers who've lost sales, there are no corresponding FBA sellers who've gained sales within the class, and that's the sort of thing that gets taken into
So is the
account.
conflict that you're identifying that part of the class claim is for FBM sales lost to FBA sellers abroad, and it should benefit the class to have as high a diversion rate as possible?
So we haven't put it that way. I'm drawing the court's attention to this because it is said to me that actually there's no reason why the tribunal would even have to look at the diversion rate at the aggregate damages stage, but there may well be circumstances when it will, and Professor Stephan intends to lead evidence on it, but additionally he also says that this is one case where this will be a matter of a finding, or maybe a matter of a finding by the tribunal. And then he gives a second example, which is that the netting off approach may not work or may not fully work if sellers with FBA offers and FBM offers have different margins. And that may well...
But at the aggregate damages stage, why do the FBA members of the class, why are they bothered if the diversion rate is high to benefit the aggregate damages at the initial stage on the basis of which you've put it?
They are bothered, I say, because whatever finding is made, whatever evidence is adduced, will then have an impact, or may then have an impact on them at the distribution stage, because the tribunal will not then be looking at all of this again, and if findings have been made, then everyone's sort of stuck with them.
Right.
And I say may because that brings me to the point I made earlier. So either that works to the detriment of FBA sellers, if then they have to give credit, or they're only able to claim a few.
So you say that findings at the initial aggregate damages stage will inevitably knock on into the distribution stage, and you say at the initial stage, the aggregate damages stage, the class rep won't know whether to argue for more or less of a diversion rate, because it would affect directly and differentially the two classes,
Precisely.
two groups within his class.
If by he won't know his loyalties are divided and he's conflicted, yes, that is what
In the same way that in trucks,
yes,
the class rep was on the one hand going to be arguing for minimum possible pass on from the buyers of new trucks, but wanted to argue maximum possible pass on for the buyers of used trucks to give them both claims.
Yes, my lord. That is why I say this case is analogous to trucks.
Yeah. Okay.
So just let me get that on board. Your submission is that at the first stage, it may become necessary for the experts' conclusions on diversion rate to be the subject of findings by the tribunal to come to an answer at stage one. It may be.
Yes.
And if that's so, those findings are then determinative for the distribution mechanism at stage two.
Yes, my lord. Yes.
And that does depend upon a part of the aggregate damages being the loss of FBM class member sales to FBA members abroad, I think.
I would say not necessarily. It is difficult to tell at this stage precisely what findings are going to be made. So
Okay. Because if the only claims were in respect of increased fees,
yes,
and the diversion rate isn't actually relevant to the methodology that's used to determine the increased fees, then there won't be any findings about the diversion rate.
So yes, Mel. So the answer is, first of all, Professor Stephan is actively proposing to lead this evidence. I appreciate the court has that point. And then secondly, Professor Stephan is also saying, and has already articulated, that there are at least 2 occasions in which it will be necessary to be making these findings.
Can you just, what can you show us it as quickly as possible or as cleanly as possible where that is said?
Yes, of course. It's in the supplemental bundle, tab 10, page 182. And it's in paragraph, it starts in paragraph 288. So that is where he says, however, I recognise that the netting off approach might not work in all cases. And then he goes on to give the first example.
And by netting off, just to be clear, the netting off is for every sale diverted from FBM to FBA, you just ignore it.
For the purposes of quantification, yes.
Yeah.
And so perhaps I'll let you read the remainder of that paragraph, which is the first example.
And so it's the last sentence of 288.
It is the last sentence of 288. And then the second example is in paragraph 289, where Dr. Hooper says, similarly, if sellers with FBA offers and sellers with FBM offers have different margins, which may well end up being an issue in this case. I mean, at this stage, I can't say whether it will or it won't based on Amazon's position, but it's perfectly possible that they would have different margins. The netting off approach, he says, might not fully compensate sellers with FBM offers, as their lost profits might not be equivalent to the gain profits by sellers with FBA offers. In this case, again, I would consider adjusting my aggregate damage estimate to reflect any material difference in margins if appropriate.
And the consequence of that is that it would increase the aggregate damages.
It may, or
well, that would be the purpose of doing it from the claimant's point of view.
Yes, correct. It could. I mean, from Amazon point of view, it could also decrease depending on where the margins fall. But yes, but those are examples of circumstances where there would be a finding, and I would add, even if there wasn't a finding by the tribunal, Professor Stephan is still leading evidence that might end up being unhelpful to some of the members of the class further down the line, even if there isn't.
And are you going to explain to us how the distribution is intended to take effect, so you can understand how it plays out?
So that varies. There is no set of rules for this particular case just yet. The compensatory principle does not apply in the usual way because it is a class action, and we entirely accept that. And so the guiding principle is that distribution must be just, and that is broadly it. So there has been a case which has gone to distribution in Gutman. It's one of the trains cases, and the way it worked there was that there were three different pots, and those depended on the amount of evidence that that class members were able to provide. And so we accept that it isn't necessarily the case that FBA sellers will necessarily get less at distribution just because they're FBA sellers and they have gained as a result of the alleged abuses. But for the reasons discussed, that does not remove the conflict because someone loses out one way or another. So either FBA sellers lose out by virtue of the fact that they've gained sales being taken into account at distribution, which is also perfectly possible, or FBM sellers lose out by virtue of being part of this claim, where, as we have discussed, the additional lost sales aren't part of, on Professor Stephan's primary plan, are not part of aggregate damages calculation, because he says they've been netted off. And that then brings me to the two errors I said that the tribunal has made.
Okay.
So, starting with the first error, the principal reason for dismissing Amazon's submissions at the CPO hearing is that the tribunal said that on Professor Stephan's theory of harm, a greater diversion rate means, up to a point, greater overcharges on logistics fees and marketplace fees. So this was put fairly obliquely in the initial CPO judgment, but we can have a clearer statement of this in the tribunal's ruling on Amazon's PTA application. So perhaps we go to that. That's in the core bundle at tab 5, page 109. Paragraph 28. So this is where the tribunal says, as regards Dr. Hubris's approach to the measurement of the overcharge, the issue is not whether Dr. Hubris intends to calculate and use the diversion rate as an input in his methodology to measure the overcharge, but that as a matter of fact, the greater the degree of diversion from FBM to FBA, the higher will be the overcharge that results from greater demand for FBA services and reduction in scale for other fulfillment providers supplying FBM.
Well, your criticism of that, as I understand it, criticisms of paragraph 28 is that ignores the fact that if there is a high rate of diversion established at the aggregate damages stage, then the likelihood is the FBA cohort will be adversely prejudiced when it comes to distribution.
In part, but my core point in respect of this error is that the tribunal appears to have regarded it as entirely irrelevant how Professor Stephan and Dr. Hubris intend to measure these various effects. So the focus appears to be entirely on what happened, the tribunal would say, as a matter of fact in real life. But what I say is that that is not something that is within Professor Stephan's control. That's not within anyone's control. What is within Professor Stephan's control is how he puts his case, what methodologies he deploys at trial, what instructions he gives to his experts, what instructions he gives to his lawyers about the objectives of any cross-examination, for example, and what to invite the tribunal to conclude at trial.
But if it were the case that on the case logic, everybody benefited at the aggregate damages stage from a high degree of diversion being established, then what's the problem?
The problem is that the interest of FBA and the FBA sellers are, given how this is being measured, the reverse.
Only when it comes to distribution.
Only when it comes to distribution.
Well,
if distribution takes a particular course.
When it comes to distribution, in one sense, that will always be the case because no one gets anything except at distribution. But what I say is that what happens at distribution will be impacted by what happens at the aggregate damages trial.
Yes. That, and you say the CAT didn't take that into account. They seem to just stop the clock at the aggregate damages stage.
In a way, so that's more has more to do with the second error. But in respect of the first error, I just wanted to make it really clear that I say that it was wrong for the tribunal to regard it as legally irrelevant what methodologies Professor Stephan is putting forward.
Right.
And the point that I've just made about the interest being opposing is a very important one, because it is said against me that this is just a matter of the seller's positions being different. But if that were all, that would of course be fine. The regime can deal with difference in position between different members of the class. But what is not okay in my submission is where the gains of some members of the class are the losses of others. So at that point, there is a conflict. And this is where I say that this is, at least arguably, analogous to trucks.
Okay.
And then there is the second error, which touches on some of the issues that we have just been discussing. So if we can have a look at paragraph 27 of Tribunal's PTA ruling. Again, this wasn't really mentioned in the original CPO ruling, but at paragraph 27, so that's core bundle, tab 5, page 108. And this is where the Tribunal says, as regards the distinct stage of distribution, it is established that distribution does not have to be compensatory in the sense of distinguishing between the different extent of loss suffered by different class members. And as a statement of law, that is correct. The problem, though, is that it doesn't address the conflict. And this brings me back to the point that we discussed earlier, and that has come up a number of times now, which is that two things might happen. First of all, sellers' diverging position might well be taken into account at distribution. That's a real possibility. Professor Stephan himself has flagged it in the past as a real possibility. And at that point, the sellers will bear the brunt of Professor Stephan's conflicted decisions as to the diversion rate. And that alone gives rise to a conflict, I say. And then alternatively, if damages were to be split equally, without regard to the fact that FBM sellers are said to have lost sales to FBA sellers, then FBM sellers will have been significantly disadvantaged by virtue of being part of this class. Because, as we've discussed, one would expect them to be seeking damages for lost sales. But here, that isn't on Professor Stephan's primary plan. That is not intended to be a part of aggregate damages assessment. So if we were to then simply split it all up evenly, as far as these factors are concerned, FBM sellers will have been disadvantaged. And so I say there is a conflict either way. And so far, I've been looking at alleged abuse 3. Unless your Lordship have any questions about that, I was going to propose to say a few words about alleged abuse 4, just to do a bit of comparing and contrasting with that. So just to wrap up on alleged abuse 4. So Professor Stephan's case on alleged abuse 4 is that sellers making FBA offers and Amazon Retail, so Amazon Retail being Amazon's own retail arm, have been favoured. The way this argument runs is that FBA offers and Amazon Retail offers are eligible for Amazon Prime, says Professor Stephan, and that the alternative route to Amazon Prime open to FBM sellers is not a viable alternative, he says. And again, it is alleged that this has a negative impact on FBM sales. So the important difference relative to alleged abuse 3 here is that third-party sellers using FBA are not said to be the only beneficiaries of this abuse. And that is because Amazon Retail, too, is said to have benefited. But this does not remove the conflict, is my submission, because if Amazon Retail is favoured as well, then the rate at which sellers who use FBA are disadvantaged, then the rate at which sellers who use FBA are disadvantaged damages claimants, by the diversion rate increasing might be less steep, so the impact of the conflict might be less steep, but the general direction of the impact remains the same. And so it is for these reasons that I submit that Amazon's appeal has a real prospect of success. I do also make submissions on other compelling reasons. What I say about that is that the class action jurisdiction is relatively new. The ordinary principles of fiduciary duty have not been modified in any way. And yet the tribunal has now repeatedly used language which simply does not map onto any of the established fiduciary law concepts. So in particular, we have two examples in this case. And perhaps I simply give you the references in the interest of time, but the first example is the tribunal has said in the CPO judgment that there is no direct conflict of interest. And so that's paragraph 146 of the CPO judgment, core bundle, tab 4, page 94. But also before then, this is the second example, in the carriage judgment, the tribunal held that there was no overwhelming problem of, that's a direct quote, overwhelming problem of conflict of interest. And that was in paragraph 86, supplemental bundle, tab 4, page 121. Now, my point is no direct conflict of interest as opposed to what? Is it being said that there's an indirect conflict of interest? And if so, what is that and why is that okay? That there are no such concepts in the established law of fiduciary duties. And the same goes for the tribunal's statement that there was no overwhelming problem of conflict of interest. And so in the circumstances, I submit that there are, in any event, other compelling reasons for the appeal to be heard. So that the question of what counts conflict of interest, whether there is a distinction between direct and indirect conflict, or where the line is to be drawn, can be addressed. And then finally, I was just going to briefly comment on a point that is being made against me, which is that this has already been decided in Barra. Perhaps I deal with it briefly, or perhaps I deal with it in a reply.
Well, you're looking at the response, are you?
I am looking at the response. I mean, at a high level, I can summarize.
It was a different argument then, wasn't it?
It is a different
Yes,
argument.
that's what the cat themselves say at paragraph 138 and following, I think.
And it's been, we've addressed it in our skeleton as well.
Okay. Right.
So perhaps I don't need to get into that now at least. But unless your lordships have any questions, those are my submissions.
Thank you very much. Right. So, Mr. Colgreen, I think first question that I've got is to try and understand what it is that you are claiming. Because I, for one, am still unsure. Can I just highlight to you why I'm unsure what is actually being claimed? And I'm focusing now on loss of profits for the FBM sellers,
Yes.
i.e. at the aggregate damages stage, to what extent is it part of your class representative's claim to say that the FBM sellers have lost in some part profits?
It's always part of the case. So those lost sales
Yep.
are always included.
And so the loss of sales at because of diversion from an FBM seller to an FBA seller,
Yes.
by abuse 3 as we've called it, is always part of the computation of aggregate damages. And as I understand it, often it's going to be netted off because as a class there's a corresponding gain of profits by some other class member, but not always if there are FBA sellers abroad.
That's right. So the claim for the lost sales is always in.
Yeah.
Sometimes the exact amount of the lost sales does not need, well, there are two preconditions.
Right. So just to be clear, I mean, perhaps we can do it quite easily. I mean, we were taken to Dr. Hoopis's report at 182 and 183 of the supplemental bundle, where I think the two paragraphs 288 and 289 where it said that the netting off approach might not fully compensate FBM sellers for their loss of profits. Are those the two? Those are the 2 points.
There are factual but also legal scenarios. So there is a legal scenario in which credit does not have to be given for the gained sales, if you like. So the FBM sellers obviously lose sales.
Yes.
And it is, in some factual circumstances, those sales go to the FBA sellers in the class.
Right.
And your lordship has already identified that there are some factual circumstances in which that doesn't quite work, because those sales go to somewhere else, for example.
And so to the extent that an FBM seller in your class has lost a sale in those other circumstances, part of the computation of aggregate damages will include a number for that.
Yes, it's always, the lost sales are always in. I think the best way to think about the...
What I couldn't understand, therefore, is if you turn to page 79 of your supplemental bundle, this is your pleading. Paragraph 190, subparagraph 1, seems to say that's not the case. Am I missing something somewhere?
That is, well, Dr. Hoopis's methodology as set out in Hoopis 1 assumes that the sales lost to the FBM sellers in the class
Cancel each other out.
and so as a methodological shortcut, he can simply say, well, the precise number, whether it's 10 or 20 or 100,
Okay, but
it doesn't matter. But he subsequently has said that there are other circumstances.
right, so the pleading is not caught up with the pleading is not caught up with what we see at we saw in the third expert report.
Yes, that's right, model. That paragraph is intended to describe Hoopis 1 figure 20.
So this is the classic sort of situation in these sort of cases that pleadings just seem to get left by the wayside and everybody just drifts off into expert reports and fights on those.
Well, my lord, I apologise if that's led to a lack of clarity, but that sentence...
You're not alone in saying that in my experience, but right.
But
Okay.
that sentence is intended to
Right.
describe that part of his report.
So the issue then is, as I see it at the moment, if part of your aggregate damages claim is going to include a number which is for lost sales to FBM, not netted off for the reasons we've described, then it benefits the FBM sellers damages claim, or the aggregate damages claim,
Yes.
to have as high a diversion rate as possible.
Yes.
When you come, point I think that came through to me is when you then come to look at distributing the pot, assuming there's a pot, the FBA claimants are going to say, no, we want a bigger proportion of that because the diversion rate wasn't actually as high as all that. And the FBM members of our class shouldn't get, as it were, a divvy of the spoils.
Yes.
Based upon that high diversion rate which was established in the proceedings earlier.
Yes, my lord. And the answer to that is this. If I can put it as in a nutshell, the diversion drives the overcharge, and the overcharge outweighs the diversion. So if I can unpack that, the point is that if you were an FBA seller, so we're currently concerned here with the possibility that the FBA seller is disadvantaged. If the FBA seller is claiming alone, the case theory that Professor Stephan is advancing on behalf of that FBA seller by themselves is that there was a diversion of sales towards FBA, and that potentially confers an advantage for which Amazon will say, or may say, that credit has to be given. But even if that's true, the net effect was always disadvantageous, because Professor Stephan's case and Dr. Hooper's evidence is that, in very basic terms, the diversion is small and the overcharge is big. So for every £1 of diversion, on current estimates, the overcharge is something like £3.30. So in order to get the best net damages result, even on an individual basis, the FBA seller will always be arguing the diversion up. Because by arguing the diversion up, that person argues the overcharge up, and therefore argues their net damages up. And therefore, this case is not like trucks. This is a case in which both the FBA seller and the FBM seller, and I pause here, my lord, just to make the brief point that those terms are actually very slippery, because not only are a lot of people mixed, but actually there's a difficult point that in the counterfactual, people might have used different logistics providers. But let's ignore all of that complexity for the time being. The point is that both the FBA seller and the FBM seller want to argue the diversion up. For the FBM seller, it's straightforward.
Well, I understand they want to argue the diversion up in order to maximise their claim for overcharging. They each will say the greater the diversion, the greater we FBAs, and I will use those slippery terms if you don't mind, just because it's easier at the moment. We, the FBA sellers, paid more because we were overcharged.
Yes.
Because we sold more and we were therefore overcharged more. And the FBM sellers will say, and we, the FBM sellers, were overcharged for logistics because we couldn't have the economies of scale. Because
Correct.
so much was going to the FBAs.
Correct.
Got that. So I understand why when they're arguing aggregate, in a sense, they will think for all reasons, let's argue for the higher level. But when we come to divide up, the FBAs are going to say, look, we were overcharged, and these are our level of our overcharge, and that's the proportion we want. And the FBMs are going to say, well, we were overcharged, and that's the proportion we want. And then the FBMs are going to say, and we lost those profits, and we want some proportion for that.
Yes.
Because we lost a lot of profits because there was a diversion. What are the FBAs going to say to that?
Well, the FBA sellers, in order to... This is why I focus on the individual FBA seller looking to maximise his own loss. The argument, if I'm an FBA seller claiming a loan, either in standalone proceedings or in the distribution pot, so just making a claim to the distributor, as it were, then the way that I make my claim the biggest is by saying the overcharge was very big, and therefore I have to argue that the diversion was very big.
Yeah.
So I don't want to say diversion was 10 and overcharge was 25 and I get 15. I want to say the diversion was 20 and overcharge was 50 and I therefore get 30. So in both scenarios, the FBA seller always wants to argue the diversion up because it is the engine of the claim. It is the case theory. The whole case theory is that because of this distortion...
Are you talking about a distribution stage or...
Both, my lord.
So can I put it this way? Obviously, the FBA wants to maximise its claim. So that's done by maximising the diversion rate at stage 1. Are you saying that, because at stage 2 you've got to make a decision, do we distribute, taking into account the differential between the amount of amount of transfers, transferred sales, or not? Is your point that whichever route you choose at stage B, the FBA seller you've identified would always be better off?
Yes, my lord, because the FBA seller, even if, as I say, even if standing by themselves in a room in front of a judge or in front of a distributor, wanting to make the claim that they suffered a lot, they will always want to say, because this is the whole case theory, that the diversion was very substantial. But there is a further legal point here, my lord, which is that even if that's not the case, which I do say it is, but even if that's not the case, if the argument is that any method of distribution will inevitably favour one group over another, that is not a point that should bar certification, because that is always true of any distribution method, because distribution is always a zero-sum game. So for the criticism to be that a PCR, or a CR as Professor Stephan is now, has to maximise recoveries for every individual class member in distribution is an impossibility.
Okay, but I think the nub of the complaint that it said the CAT didn't grapple with is that at the aggregate damages stage, the decision to push for a higher diversion rate in order to maximise the aggregate damages will have knock-on effect at the distribution stage, and the FBM people will be stuck with, FBA people will be stuck with whatever findings are made about the diversion rate at the aggregate damages stage.
I do say that the CAT took that into account. If we go back to paragraph 28 of the PTA ruling, to which my learned friend drew your attention, and the point that the tribunal makes in the penultimate sentence of that paragraph is sellers using FBA, sellers using FBM, and sellers using both all have an interest in contending that there was a high rate of diversion.
But they're addressing there that the higher the overcharge, just generically, aren't they?
Well, if the diversion drives the damages,
yeah.
Essentially what we're saying here is, in order to get big damages, you need to say that there was a big diversion. That's essentially the link. Whether that's true on an individual basis, on an aggregate basis, or at distribution, it's always true because it is the case, and it is the case theory. So it may well be that at the diversion stage, the FBA seller would like to come along and say, "Oh, I'd actually like to change the case and say that there was no diversion." But the point is that would totally undermine the case in the first place.
There's a trade-off, isn't there? The FBA seller is undertaking this point, which is, I recognise that I'm going to be better off if there's a higher diversion rate in terms of upping the aggregate damages. I recognise that means I can't come back at the distribution stage and say, well, actually, I'd now like to argue for a different rate.
Because then they would have no case in the first place to get damages in the first place. So
that's because the benefit of overcharge, or the detriment of overcharge, is greater than the detriment of the transfer.
That's right. That's right. So it's a trade-off, or perhaps just a trade, in the sense that in order to have any case at all on the overcharge, the seller has to make this argument on the diversion. It's just something they have to do. So it's not properly thought about.
Better to have a marginally reduced share of a much bigger pie than a smaller pie.
Yes, Mark. And that's not something that they have a choice about. If there is a case at all here, they must make that argument. And so that is really the core of our answer, is to say that Amazon's error is to effectively take the FBA seller's case and to slice it into small bits, and to say, well, just look at the effect of the diversion, to which the answer is no, because this case is primarily about overcharges, and so one must consider the... Is there anywhere where there's any attempt to substantiate the point you've made that the level of the overcharges significantly outweigh the lost profits, if I can put it that way, to the... Yes, my lord. So in Hoopis 2, which is not in the bundle, Dr. Hoopis specifically addressed this, because it was in fairness, it's not. I'm not suggesting it's been suppressed at all. It's simply that that was prepared for the purposes of the carriage hearing. But in Hoopis 2, he makes the point that the overcharge outweighs the diversion. And then he revisits that in Hoopis 3. And we see that is in the body. Supplementary tab 10. Paragraph 282.
You've got a page number, I don't have tabs.
I beg your pardon. It's page 180 of the bundle, 182 of the PDF.
Paragraph.
And beginning at paragraph, if I could ask the court to read paragraphs 280 to 283.
So you wanted us to read 280
280 to 283. The core of it is 282, where Dr. Hoopis says the relationship depicted in Mr. Holt's figure 2, and you'll recall, my lords, that this is the downward sloping graph that basically tries to visually illustrate the point that arguing the diversion up drives damages down. He says does not exist. As the level of diversion increases, the level of FBA overcharge would also be expected to increase, and damages would also rise for so-called FBA sellers. And this is effectively the evidence that the tribunal evaluated and accepted in its judgment when it then said, in the main judgment as well, but we've seen it most recently in the PCA ruling, that every seller, including the FBA seller, has an interest in arguing for the diversion to be higher because that's what gives it higher damages, even on an individual basis, not just on an aggregate basis. And so he then says, well, therefore, the line presented on the left-hand side should be expected to be upward sloping. So what he's saying there is instead of diversion up, damages down, the slope is up, diversion up, damages up.
And is it 283 where the tribunal previously agreed that it's not very plausible that you'd have the reverse, where the diversion outweighs the overcharge?
There is a sort of theoretical. It was posited that there was a theoretical possibility that if the diversion was so gigantically enormous, it's possible that would effectively wipe out the overcharge. But the problem with that is it's a very implausible. It's not only it's unevidenced case, but it's a highly implausible case because it posits that an FBA seller would continue to use FBA despite the fact that it was producing no sales in the counterfactual. So it's an implausible case. It's one that we're not putting. It's certainly not one that Amazon is putting. We've now seen Amazon's defense, and we know that Amazon is going to be arguing that the effect will be negligible, which means that everybody in Professor Stephan's class is going to have to effectively reply to that defence on the basis that the effect was large.
Okay, right. Well, bearing in mind the time.
Yes, Moro, I appreciate I'm in injury time. No time's over.
That's fine. Thank you very much. Thank you. So, I mean, Ms. Lukova, do you want to say anything in quick response? You've got about 3 or 4 minutes left, I think.
Yes, thank you, members. So first of all, Mr. Carroll Green's diversion drives overcharge point. That is why I place a lot of emphasis in my earlier submissions on the fact that these effects are being measured separately and independently in this case. So it could perhaps be said, as Mr. Carroll Green says in part, that arguing for a higher diversion rate might have some benefit for sellers who used FBA, in the sense that that would render Dr. Hoopus's measured overcharge more plausible. But what I say is that there is still a real conflict here. And that is because arguing for a higher diversion rate is always a clear benefit to FBM sellers, because that would mean that they've lost a higher volume of sales. But in contrast, for sellers who used FBA, there is also a clearer direct cost to arguing for a higher diversion rate. And because the obverse, that is because the obverse is true for them. The higher the diversion rate, the more sales they have gained as a result of the abuse. And what I say is that Professor Stephan cannot act as the arbiter of whether it is in their interest to incur that cost in the hope that the benefits of making the overcharge claim more plausible outweigh the cost. There is also, there were parts of Mr. Carroll Green's submissions that almost sounded as if these class members were here with us making these decisions. Now, of course, they're not. This is an opt-out claim, which means that we are currently proceeding on the basis that anyone who hasn't chosen to opt out is a member of the class. And I would simply draw the court's attention to the established principles that if there were to be an actual conflict, then of course the class representative cannot act at all. But even if there were to be merely a potential conflict, it still couldn't act without the fully informed consent of each class member, which in this case would simply not be viable because we're in the territory of an opt-out claim. And so to the extent that it sounds almost as if informed consent has been given, that is not what we're looking at here at all. And that concludes my submissions.
Can I just follow up on one thing? So,
Yes.
Do you accept the proposition that the individual FBA seller, if they were acting alone, would be arguing for a higher diversion rate because the amount of overcharge they're going to claim by way of damages will always outweigh any downside because of the diversion?
So first of all, of course, from Amazon's perspective, we don't accept any of that.
No, of
but
course,
I mean, on
yes.
Professor Stephan's theory of harm,
Yes.
based on the report, it sounds like that would be the case for a period of time until it would eventually drop.
But I think that's when it would drop is the implausible scenario as found by the CAT previously.
That is what Professor Stephan says. The CAT has previously largely focused on when the FBA sellers would end up in a position where they can't claim any damages at all. That is a function of how BARA, the competing class representative, had run its case. They were saying that FBA sellers, if they thought about it, wouldn't be running Abuse 3 at all because, in fact, they might end up losing money as a result of it because actually the losses of sales might outweigh the overcharges. And that is why the tribunal was focusing on the point at which FBA sellers would have lost zero in the context of Abuse 3. That isn't the relevant point for the purposes of these arguments because before the losses hit zero, of course, they will have started falling. So there's a point at which they will have started falling. But I'm certainly not running this claim on the basis that we will be saying that that the diversion rate or the overcharge have been gigantic. I am not doing that. What I'm doing is putting forward a case where I say it doesn't matter how large the diversion rate is in any event there's a conflict.
One slight curveball. If it was the case that there was no material conflict at this stage, because we were persuaded that everybody in the class would want to argue for a high diversion rate at this stage, but there was a potential problem further down the track. What's to stop the cat further down the track? Putting in place, for example, a Chinese wall of the arrangement like was put in place in trucks to deal with a situation which might arise further down the track.
Well, first of all, on my case, that would be too late because there's an actual conflict now.
Yeah, well, I said, but on the hypothesis that we didn't think there was an actual conflict now, then can it be addressed later? Then
even if there were merely a potential conflict, in the sense that a reasonable person might take the view that there's a real possibility of one, that still does not help because the established principles say that where there is a potential conflict, one can only act with fully informed consent of the principal. And in the context of this claim, that isn't viable. If there's a further question of whether practically the cat might be able to do something further down the line, I would say that wouldn't be the appropriate way forward in these circumstances for the reasons that I have given. But additionally, that could be highly disruptive to the proceedings. And so I would invite this court to have regard to trucks, where it was thought that in circumstances where there is a conflict, the time to address it is as soon as possible, as soon as it arises, rather than deal with it later.
Okay, thank you very much.
My Lord, I'd be grateful if the opportunity to answer the two questions that the court has put just now in brief.
Brief.
The first question was whether or not Amazon has accepted the link between the diversion and the overcharge and the damages. I would respectfully draw the court's attention to paragraph 107 of Amazon's skeleton argument before the Competition Appeal Tribunal, which appears at Supplementary Bundle 189, where it does so accept. In order to be brief, my Lord, I may move to the second answer. The court's second question was about effectively can the cat do something later? The simple answer to that is yes, but I would also ask the court to bear in mind Rule 92 of the tribunal's rules, which provides a specific mechanism for disputes about distribution to be adjudicated by an independent person and or the tribunal when you get there. And that, I emphasise, was referred to by the Supreme Court in Merricks, in the unanimous part of the judgment.
Right, well, thank you all. Well, doesn't time fly when you're enjoying yourself? It won't come as any surprise. We're going to, I think, reserve judgment on both questions of permission to appeal. We will endeavour to give you our response, our decision and some reasons in the normal way, so you'll get a draft judgment. It'll come out to the, if you haven't already supplied email details for counsel and others to receive a draft judgment, can I ask that you do so by the end of tomorrow to my clerk, because after the end of tomorrow my clerk won't be my clerk. I'll be in with another one. So if you could please, if you haven't already been asked to provide those details to us, provide them by the end of tomorrow, those who want to receive a draft judgment. When you do get the draft judgment in the usual way, it'll be for corrections of syntax typos, not for re-argument, and it will come with the usual embargo on the top, which means what it says, and you will understand, of course, I know that the court takes very seriously adherence to that embargo. I'd rather hope that, given the stage we're at, thereafter there won't be any dispute over producing a draft order, but depending on what we do, we may ask you for, we would ask you to agree a draft order and give us brief written submissions if you cannot, but that will all come out with the draft judgment. And then we'll deal with any consequentials on paper. No, other than to thank you all very much, and as I said, I'm sorry it's taken a little longer than perhaps advertised, but thank everybody, both in the front row and sitting behind. Thank you very much.
All rise, evil.